Okay. Thomas is decided to write an anti-special counsel manifesto in this opinion, and so we were reading through that. Regardless, this provision would be a curious place for Congress to hide the creation of an office for a special counsel. It is placed in a chapter concerning the Federal Bureau of Investigation, not the separate chapters concerning the U.S. attorneys or the now lapsed independent counsel. To be sure, the court gave passing reference to the cited statutes as supporting the appointment of the special prosecutor in United States v. Nixon, but it provided no analysis of those provisions' text. Perhaps there is an answer for why these statutes create an office for the special counsel. But before this consequential prosecution proceeds, we should at least provide a fulsome explanation of why that is so. Even if the special counsel has a valid office, questions remain as to whether the Attorney General filled that office in compliance with the Appointments Clause. For example, it must be determined whether the special counsel is a principal or inferior officer. If the former, his appointment is invalid because the special counsel was not nominated by the President and confirmed by the Senate, as principal officers must be. Even if he is an inferior officer, the Attorney General could appoint him without presidential nomination and senatorial confirmation only if Congress by law vested the appointment in the Attorney General as a head of department. So the special counsel's appointment is invalid unless a statute created the special counsel's office and gave the Attorney General the power to fill it by law. Whether the special counsel's office was established by law is not a trifling technicality. If Congress has not reached a consensus that a particular office should exist, the executive lacks the power to unilaterally create and then fill that office. Given that the special counsel purports to wield the executive branch's power to prosecute, the consequences are weighty. Our Constitution's separation of powers, including its separation of the powers to create and fill offices, is the absolute central guarantee of a just government and the liberty that it secures for us all. There is no prosecution that can justify imperiling it. Let's do this. Okay. Chief Justice Roberts writing the majority opinion. That was this. Then we have Clarence Thomas concurring, argues there is no ability for the special counsel to exist. In this case, there has been much discussion about ensuring that a president is not above the law. But, as the court explains, the president's immunity from prosecution for his official acts is the law. The Constitution provides for an energetic executive because such an executive is essential to the security of liberty. Respecting the protections that the Constitution provides for the office of the presidency secures liberty. In that same vein, the Constitution also secures liberty by separating the powers to create and fill offices, and there are serious questions whether the Attorney General has violated that structure by creating an office of the Special Counsel that has not been established by law. Those questions must be answered before this prosecution can proceed. We must respect the Constitution's separation of powers in all its forms, else we risk rendering its protection of liberty a parchment guarantee. So when he does this, writing here, is he asking somebody else, can somebody else please challenge this in court so that I can strike it down? Or what is the okay, I don't know why I'm asking you fucking losers. Fuck you guys. Then we have Justice Barrett concurring in part. Destiny, are either of these potentially criminal or both immune from judicial review? Jackson implementing the Trail of Tears legislative act, or Roosevelt putting the Japanese in internment camps executive order? I don't know enough about the details of either of those to give you an accurate assessment. Okay, Thomas was a full concurring. Okay. Okay. What is Roberts' first name? Justice Roberts. Jane, really? Wow. I was unaware. It's John Roberts. Okay. and then it's Amy Comey Barrett, right? No, Coney. Amy Coney Barrett. Amy Coney Barrett, concurring in part. Okay, we'll see what she says. For some reason, she was supposed to be the most unhinged of the new conservative appointments. I feel like most of the stuff she's written has been pretty fair, but we'll see what she says here. For reasons so concurring in part means that she is voting to, she's voting with the majority. She's concurring, meaning that whatever the ultimate question was that was to be determined by the court, she is agreeing with that. She's giving it an upvote. But when she says concurring in part, that means that there should be a substantive part of the majority ruling that she disagrees with, even though she still supports in totality the decision. For reasons I explained below, I do not join Part 3C of the court's opinion. Okay. Court 3C. Do I need to go back and look at this, or is she going to talk about what that was? Let's just go check it real quick. Fuck me. Oh, 3C. Oh, A, B, C. And then 4? Is this right? Was this 3C? I don't know which C this is. That's 4. Okay. 3C. The essence of immunity is its possessor's entitlement not to have to answer for his conduct in court. Presidents, therefore, cannot be indicted based on conduct for which they are immune from prosecution. Indicted based on conduct for which they are immune from prosecution. Oh, this has to do with considering evidence from immune acts as well, that you can't even use them as evidence for other crimes. So she's going to disagree with that part. Interesting. Okay. So she dissents in part, but her view still counts as full approval for the ruling? No. I don't think you can... Wait, can you dissent in part? I think you just concur in part. And then if you dissent, you dissent. That means you disagree with the ruling. I don't, can you dissent in part? I think you can only concur in part, or you just dissent. I think, but who knows? Google it. The remainder of the opinion is consistent with my view that the Constitution prohibits Congress from criminalizing a president's exercise of core Article II powers and closely related conduct. That said, I would have framed the underlying legal issues differently. The court describes the president's constitutional protection from certain prosecutions as an immunity. As I see it, that term is shorthanded for two propositions. The president can challenge the constitutionality of a criminal statute as applied to official acts alleged in the indictment, and he can obtain interlocutory review of the trial court's ruling. Let's see. The president can challenge the constitutionality of a criminal statute as applied to official acts alleged in the indictment, and he can obtain interlocutory review of the trial court's ruling. Interlocutory review. I don't know what that means. Interlocutory review. The term interlocutory is used to indicate a lack of finality. An interlocutory appeal is an appeal to a non-final order issued during the course of litigation. The collateral order doctrine sets forth the rules for such appeals. Interlocutory appeals are extremely rare, and a three-part test determines whether the collateral order exception to res judicata makes such an appeal possible. Res judicata, am I pronouncing this right? Why doesn't it ever give me pronunciation?
We are looking at, so make sure to stay pronouncing the first word in English, res or raise. So res judicata or res
judicata.
res judicata.
Res judicata. Okay. A three-part test determines whether the collateral order exception to res judicata makes such an appeal possible. 1, the order must have conclusively determined the disputed question. The order must resolve an issue completely separate from the merits of the action. The order must be effectively unreviewable on appeal from a final judgment. Is there like a... Legal U.
Sometimes rulings need to be addressed before the end of the game. In football, we call this an instant replay. When a ruling is challenged before the trial court enters an appealable judgment, this is called an interlocutory appeal. Interlocutory is a fancy legal word which comes from a Latin word for to speak between. An interlocutory appeal is when a ruling is reviewed by an appellate court before all claims are resolved for all parties involved.
Oh, interesting. So basically does this mean that like in the middle of a trial, or would this still be a pre-trial thing? Or could it be in either? So you're basically appealing a part of a case before the case is even done. Okay.
Typically, before an order is appealable, the case must be finalized in what is called, well, a final order. But when an order doesn't decide the whole case, it's called a non-final order. A non-final order can only be appealed in accordance with certain rules. The following types of non-final orders are eligible for immediate appeal. Orders that rule on venue, injunctions, personal jurisdiction, the right to immediate possession of property, class certification, arbitration entitlement, workers' comp immunity, and qualified immunity. Also, in family law matters, immediate monetary relief or child custody. But there are times when an order doesn't qualify as one of these non-final appealable orders, but still needs immediate review by the appellate court. Generally, these involve immediate harm that can't be prevented or fixed by a normal appeal after a judgment has been entered. In these situations, you may be able to get an appellate court to look at the ruling using what is called an extraordinary writ. As you might guess, writ is just an ancient way of saying written. It just means a written court order to act or abstain from acting in some way. The most important ones, for civil litigation anyway, are writ of certiorari, writ of prohibition, and a writ of mandamus. Certiorari is Latin meaning to be informed of. Writ of certiorari, besides being difficult to say, is the jack-of-all-trades writ.
I think this is generally the one that when people are writing to the Supreme Court, like you see this in all of our Supreme Court decisions we have to review, these are writs of certiораries.
Its role and scope may vary depending on what court you are in, but it functions as a safety net. It's there to halt a miscarriage of justice when no other remedy exists. A writ of prohibition is when a higher court orders a lower court to cease litigation because it lacks jurisdiction. And a writ of mandamus, which is an order from a higher court to a lower court or public official, forcing them to do something that they are already required by law to do. Appealing, whether interlocutory or otherwise, is something that requires the right kind of moves. The legal you kind. Legal you, where you are your own best lawyer.
What a horrible idea. Don't do it. Okay. Wow, call me Mar100. Thanks for gifting 10 memberships in YouTube chat. Okay, so the president can challenge the constitutionality of a criminal statute as applied to official acts alleged in the indictment. And then he can obtain interlocutory review of the trial court's ruling. So Amy is basically saying, or I'm sorry, I should say, Justice Barrett is saying here that the president is allowed to challenge the constitutionality of a criminal statute by saying that, like, well, this wouldn't apply here by way of the Constitution to this particular act, and I can interrupt a court ruling, or I can do this in pretrial to say that, like, we're never even going to court over this, basically. So she's saying this here, okay. There appears to be substantial agreement on the first point. Like the court, the dissenting justices and the special counsel all accept that some prosecutions of a president's official conduct may be unconstitutional. I think we can all agree with that, right? I think that's fair. See post at 16, blah, 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 brief, blah, blah. As for interlocutory review, our precedent recognizes that resolving certain legal issues before trial is necessary to safeguard important constitutional interests. And then here, I think we can all agree on that as well. For instance, I probably shouldn't be able to sue, I shouldn't be able to sue the president for some essential, I shouldn't be able to sue the president and say, I don't think you actually should have classified this nuclear secret. Let's go to court and argue about it and have everybody look and see. And then you argue about it and blah, blah, blah. And it's like after the whole thing, you're like, okay, you're right. We never, or actually you lose, you're wrong. Despite the fact that we just gave you discovery and a jury of normal citizens saw it, this nuclear secret actually really did need to be completely secret. But since we went to court, it kind of doesn't matter now. Everybody that was part of the process knows, right? So there are definitely, Justice Barrett is fair here when she says that some questions should never be asked of the president, right? You should probably never be able to criminally indict a president as like the commander-in-chief, or maybe in highly exceptional cases, maybe. And also that some criminal questions that might be asked of the president, some criminal matters, probably should just never go to court. There should be some ways that we could block this before it's decided in court. I think all of us, every reasonable person, I think, should be able to say there's at least strong arguments to favor that, right? Properly conceived, the president's constitutional protection from prosecution is narrow. Oh, fuck. Am I about to be a huge Justice Barrett simp? I read her concurrence in the, what was the, in that Section 14, or the 14th Amendment Section 3 case, and I thought her concurrence, I thought was very fair. But she's concurring with the decision still. But why would she concur? It's a 6-3 decision anyway. Are judges allowed to confer with each other before they finalize it? Like, why not 5-4 it? Because she doesn't want to show division in the conservative part of the court. That shouldn't matter. Because she still does concur. Because they don't know their decisions. I don't know. We'll see. Properly conceived, the president's constitutional protection from prosecution is narrow. Like, I hope that what she addresses in the rest of her concurrence is, listen, guys, I agree, broadly speaking. No, I agree conceptually with what the court is saying. But the problem is that they've opened with this presumptive immunity, and even with some of their absolute immunity, they've opened the question on how much presidential power is unquestionable and can't even be criminally reviewed. That's crazy. That's what I hope. That's what I hope she says. But let's see. Okay. The court leaves open the possibility that the Constitution forbids prosecuting the president for any official conduct, instructing the lower courts to address that question in the first instance. See ante at 14. I would have answered it now. Though I agree that a president cannot be held criminally liable for conduct within his conclusive and preclusive authority and closely related acts, the Constitution does not vest every exercise of executive power in the president's sole discretion. Congress has concurrent authority over many government functions, and it may sometimes use that authority to regulate the president's official conduct, including by criminal statute. Article 2 poses no barrier to prosecution in such cases. So Amy's bringing up something here that Roberts already said. He said, sure, there is overlap. That's why we would call it presumptive immunity. But she's also saying that there is no separation of power issues. There's no separation of powers issue by having Congress regulate the president's official conduct, including by criminal statute. I would thus assess the validity of criminal charges predicated on most official acts, i.e., those falling outside of the president's core executive power, in 2 steps. The first question is whether the relevant criminal statute reaches the president's official conduct. Not every broadly worded statute does. For example, Criminal Statute 956 covers conspiracy to murder in a foreign country and does not expressly exclude the president's decision to, say, order a hostage rescue mission abroad. 18 U.S.C. 956, subsection A, the underlying murder statute, however, covers only unlawful killings. Section 1111 or whatever, the Office of Legal Counsel has interpreted that phrase to reflect a public authority exception for official acts involving the military and law enforcement. Memoranda from blah, blah, blah. Okay. We'll read her footnotes because she's not fucking retarded like Roberts. Consistent with our separation of powers precedent, I agree with the court that the supervision and removal of appointed high-ranking Justice Department officials falls within the president's core executive power. I do not understand the court to hold that all exercises of the take-care power fall within the core executive power. I agree with the dissent that the Constitution does not justify such an expansive view. Okay. Okay. And she even brings up against Sheikh Anwar al-Awlaki. That's the case that she's citing. Oh, it was when the Office of Legal Counsel was giving their opinion on the legality of that. The thing she's citing to is applicability of federal criminal laws and the Constitution to contemplate illegal operations against Sheikh Anwar al-Awlaki. I express no view about the merits of that interpretation, but it shows that the threshold question of statutory interpretation is a non-trivial step. That's a good point, because Roberts said, you want us to allow unconstitutional things and leave it to the discretion of the judiciary? I'm sorry, sir. Here's a quote from an irrelevant court case. We would never trust the judiciary with non-constitutional things on the books, right? And Amy is countering. She's saying, well, actually, the statutory interpretation is not just anything. Like, there is valid ways to do these types of interpretations that also still conserve the core functioning of the president without requiring such broad immunity. If the statute covers the alleged official conduct, the prosecution may proceed only if applying it in the circumstances poses. Is this a typo? Should that be if? If the statute covers the alleged official conduct, the prosecution may proceed only if applying it if the circumstances poses no danger of intrusion on the authority and function of the executive branch. On remand, the lower courts will have to apply that standard to various allegations involving the president's official conduct. Some of those allegations raise unsettled questions about the scope of Article II power, but others do not. For example, the indictment alleges that the president asked the Arizona House Speaker to call the legislature into session to hold a hearing about election fraud claims. Let's read her footnote here I should read the footnotes as they come up, I'm sorry. This analysis is unnecessary for Okay, hold on. She's talking about, on remand, the lower courts will have to apply that standard to various allegations involving the president's official conduct. This analysis is unnecessary for allegations involving the president's private conduct because the Constitution offers no protection from prosecution of acts taken in a private capacity. Sorting private from official conduct sometimes will be difficult, but not always. Take the president's alleged attempt to organize alternate slates of electors. In my view, that conduct is private and therefore not entitled to protection. So she's taking a very narrow view of what she would consider official conduct, although it feels like Roberts is taking a highly expansive view of what he considers official conduct. The Constitution vests power to appoint presidential electors in the states, and while Congress has a limited role in that process, the president has none. In short, a president has no legal authority and thus no official capacity to influence how the states appoint their electors. I see no plausible argument for barring prosecution of that alleged conduct. I wish that, you know what is actually really fucking irritating now? Because Justice Barrett wrote her thing as a concurrent, it feels like there wasn't pressure on Roberts to respond to any of it. I wonder if that factors into them writing a concurring opinion or a dissenting opinion. Because if she would have wrote a dissenting in part, I feel like Roberts would have had to. Address her dissent, but now he basically just ignores all of it. But. What is the core that they are concurrent on? The core issue that they're concurrent on is an issue that all of us should be concurrent on, is that the president should probably have some actions that are beyond judicial review, that are in his official capacity. That's fair. And she's concurring with that part, but she's saying, but hold on, but what you guys consider official actions is really wild. It's almost like, you have a law that says police officers should be legally allowed to shoot people. And Roberts and Barrett both agree on this, but Roberts is saying that shoot can be anything. It could mean shooting a pistol, it could mean shooting a water gun, or it could mean shooting cum on them with your cock. And And Barrett is like, I agree, he's right. Cops should be able to shoot people. I mean, I basically agree with him completely, yeah. But I mean, it should probably only be bullets, not like the other stuff he's talking about. She's agreeing in part, but in my opinion, the trivial part of the ruling, even though it makes up the core of the ruling, that's not really a thing that I believe most legal people would have issue with. But, you know, I don't know. Well, does a 6-3 decision have more authority than a 5-4 decision? Nope. Some of those allegations raise unsettled questions about the scope of Article 2 power, but others do not. For example, the indictment alleges that the president asked the Arizona House Speaker to call the legislature into session to hold a hearing about election fraud claims. The president has no authority over state legislatures or their leadership, so it's hard to see how prosecuting him for crimes committed when dealing with the Arizona House Speaker would unconstitutionally intrude on executive power. Destiny, but even then you agree some official action shouldn't be questioned. You agree they can be examined for motive if a crime is alleged, right? Maybe. It would depend on how narrow you want to make those acts. If it's narrow enough, I could probably be fully on board with it. Or at least if I disagreed with it, I can see the argument that it's like, I don't really agree, but I get it. Yeah, I don't like it, but I get it. If it's narrow enough. But the wider that becomes, the more ridiculous the ruling becomes. It would be like if you take a guy who like never wants to be fucked in the ass ever, and it's like, okay, well, you have to be fucked in the ass. Do you want to be fucked with a 1-inch pencil, or do you want to be fucked with a 20-inch dragon dildo, right? And it's like, okay, well, if you're going to fuck me with a 1-inch pencil, fine, fuck it. I'm not really here for it, but whatever. But the dragon dildo is like significantly more anally expansive, or here, executive power immunity expansive, but... This two-step analysis, considering first whether the statute applies and then whether its application to the particular facts is constitutional, is similar to the approach that the special counsel presses in this court. It is also our usual approach to considering the validity of statutes in situations raising a constitutional question. An important difference in this context is that the president is entitled to an interlocutory appeal of the trial court's ruling. A criminal defendant in federal court normally must wait until after trial to seek review of the trial court's refusal to dismiss charges. But where trial itself threatens certain constitutional interests, we have treated the trial court's resolution of the issue as a final decision for purposes of appellate jurisdiction. Where was footnote 3? Wait, am I fucking blind? Oh, I see. The court has sometimes applied an avoidance canon when interpreting a statute that would interfere with the president's prerogatives. The Office of Legal Counsel has advocated for a clear statement rule if applying a statute would raise serious constitutional questions relating to the president's constitutional authority. In my view, neither canon applies in this circumstance. Courts should instead determine the statute's ordinary meaning and, if it covers the alleged official acts, assess whether prosecution would intrude on the president's constitutional authority. See public... Okay, that makes sense, right? Yeah. So, like, for instance, I don't know if this would be the path that ordinary legal stuff would take, but if somebody were to say, hold on, I want to sue like an FBI agent for kidnapping, and I want to point to this criminal thing or whatever, you say, well, hold on. Like, if we look at how this crime is written and we look at who it applies to, and then we look at the power that's granted to this particular body, clearly there's a conflict here, but clearly the textual, interpretation of the power granted to the body means that they'd be exempt from said statute, or the statute itself. I guess she's saying now the courts are requesting that, well, hopefully these statutes just provide an exemption clause so that we can just, we don't have to deal with these issues in the courts at all. But
hello.
Hi, what's up?
Yeah, you said you'd be okay to discuss the Joe Biden-Trump debate a little bit.
Fuck, I lied. Tomorrow, okay? I'm still reading through this. Sorry, it's taking me a lot longer.
Okay.
I love you.
All right, take care. Make sure you feed your cats vegan. Bye-bye.
Got it. The present circumstances fall squarely within our precedent authorizing interlocutory review. When a president moves to dismiss an indictment on Article 2 grounds, he makes no challenge whatsoever to the merits of the charge against him. He instead contests whether the Constitution allows Congress to criminalize the alleged conduct, a question that is collateral to and separable from his guilt or innocence. Moreover, the president's executive branch authority would be significantly undermined if appellate review of the constitutional challenge were postponed until after conviction and sentence. The prospect of a trial court erroneously allowing the prosecution to proceed poses a unique danger to the independence of the executive branch. As the court explains, the possibility that the president will be made to defend his official conduct before a jury after he leaves office could distort his decisions while in office. These Article 2 concerns do not insulate the president from prosecution, but they do justify interlocutory review of the trial court's final decision on the president's as-applied constitutional challenge. I wonder then if she disagrees wholly with the absolute immunity claim. I'm curious if she mentions that, but or maybe she already has. I don't know. I understand most of the court's opinion to be consistent with these views. I do not join Part 3C, however, which holds that the Constitution limits the introduction of protected conduct as evidence in a criminal prosecution of a president beyond the limits afforded by executive privilege. I disagree with that holding on this score. I agree with the dissent. She's agreeing with Sotomayor. The Constitution does not require blinding juries to the circumstances surrounding conduct for which presidents can be held liable. Consider a bribery prosecution. Oh, and she's bringing up the one-legged stool example. Consider a bribery prosecution, a charge not at issue here, but one that provides a useful example. The federal bribery statute forbids any public official to seek or accept a thing of value for or because of any official act. The Constitution, of course, does not authorize a president to seek or accept bribes, so the government may prosecute him if he does so. Yet, excluding from trial any mention of the official act connected to the bribe would hamstring the prosecution. To make sense of charges alleging a quid pro quo, the jury must be allowed to hear about both the quid and the quo, even if the quo, standing alone, could not be a basis for the president's criminal liability. Now remember, even though Barrett is making this argument, the majority opinion disagrees, and that's not what's been forwarded by the court. The court is not concurring with Amy in this part. This is a part that she is disagreeing with the court on. So I appreciate the court's concern that allowing into evidence official acts for which the president cannot be held criminally liable may prejudice the jury, but the rules of evidence are equipped to handle that concern on a case-by-case basis. And see, Barrett is trusting a little bit more, as she should be, the federal prosecutorial guidelines. We have rules for evidence. You have interlocutory appeal in pretrial. You have rules for indictments. You have judges and prosecutors are involved. You've got many different steps here. Now, Roberts says, fuck all that shit. None of these guys can be trusted to deal with the exemplary office of the presidency. They would all be biased, and they'd all be corrupt, and they'd all be fucked. And Barrett is saying, well, hold on. There's a lot of stages in between this shit. There's probably other parts, as she said even earlier, that like even challenging a statute itself, you know, these are, on whether they'd apply to the president, these are non-trivial steps, you know, that are for review at every stage here, you know. But the rules of evidence, okay. Most importantly, a trial court can exclude evidence of the president's protected conduct if its probative value is substantially outweighed by a danger of unfair prejudice or confusing the issues. Federal Rule of Evidence 403, see also Rule 105, requiring the court to restrict the evidence to its proper scope and instruct the jury accordingly. The balance is more likely to favor admitting evidence of an official act in a bribery prosecution, for instance, than one in which the protected conduct has little connection to the charged offense. And if the evidence comes in, the trial court can instruct the jury to consider it only for lawful purposes. See, blah, blah, blah. I see no need to depart from that familiar and time-tested procedure here. The Constitution does not insulate presidents from criminal liability for official acts. That's a departure from, in my opinion, probably the most important part of the majority rule, but okay. A criminal statute is no exception, thus a president facing prosecution may challenge the constitutionality of a criminal statute as applied to official acts alleged in the indictment. If that challenge fails, however, he must stand trial. We would say Barrett disagrees that official acts can't be probed or presented as evidence in a criminal trial, even if those particular acts would ordinarily be immune from criminal prosecution. Barrett also doesn't seem to agree with an expansive view on the absolute immunity argument forwarded by Roberts, but instead seems to view official conduct with a much more narrow lens, citing the conversations Trump has with election officials as falling squarely into private conduct, whereas Roberts remanded those questions to the lower courts. Now we have Sotomayor writing the dissent, joined by Kagan and Jackson. Sonia Sotomayor. Elena Kagan and I don't know their first names. Katanji, or is it Katani? Okay. Okay. Justice Sotomayor, with whom Justin Kagan and Justice Jackson join, dissenting. Today's decision to grant former presidents criminal immunity reshapes the institution of the presidency and makes a mockery of the principle foundational to our Constitution and system of government that no man is above the law. Relying on little more than its own misguided wisdom about the need for bold and unhesitating action by the president, the court gives former President Trump all the immunity he asked for and more. Because our Constitution does not shield a former president from answering for criminal and treasonous acts, I dissent. I don't like the that quote from Thomas where he's like, nobody's above the law, including Trump. The law just says that Donald Trump is above the law, but he's not above the law because it's written into the law that he's above it, obviously, right? It's like, it's very circular. I just feel like it's kind of dumb, in my opinion, right? It would be like writing a constitution. This is like, oh, the king cannot be held criminally liable for anything ever. And then somebody's like, this is bullshit. You've got a king that's like above the law. You're like, no, what are you talking about? The law literally says right there, the king just can't be held criminally liable, but it's part of the law, you dipshit. Like, well, you're kind of missing the point of what's being said, you know? Yeah, but feels a bit circular, in my opinion. That's such a disingenuous reading of Thomas's words. No, that's almost an exact quote from what Thomas said. In this case, there has been much discussion about ensuring that a president is not above the law. But, as the court explains, the president's immunity from prosecution for his official acts is the law. I'm almost quoting him verbatim. You dipshit, you uneducated fucking ape. Okay. Anyways. The indictment paints a stark portrait of a president desperate to stay in power. In the weeks leading up to January 6, 2021, then President Trump allegedly spread lies that there had been outcome determinative fraud in the election and that he actually won. Despite being notified repeatedly by his closest advisors that his claims were untrue. When dozens of courts swiftly rejected these claims, Trump allegedly pushed officials in certain states to ignore the popular vote, disenfranchise millions of voters, dismiss legitimate electors, and ultimately cause the ascertainment of and voting by illegitimate electors in his favor. It is alleged that he went so far as to threaten one state election official with criminal prosecution if the official did not find 11,780 votes. The 11,780 votes Trump needed to change the election result in that state. When state officials repeatedly declined to act outside their legal authority and alter their state election processes, Trump and his co-conspirators purportedly developed a plan to disrupt and displace the legitimate election certification process by organizing fraudulent slates of electors. As the date of the certification proceeding neared, Trump allegedly also sought to use the power and authority of the Justice Department to bolster his knowingly false claims of election fraud by initiating sham election crime investigations and sending official letters falsely claiming that the Justice Department had identified significant concerns that may have impacted the election outcome, while falsely presenting the fraudulent electors as a valid alternative to the legitimate electors. When the department refused to do as he asked, Trump turned to the vice president. Initially, he sought to persuade the vice president to use his ceremonial role at the January 6 certification proceeding to fraudulently alter the election results. When persuasion failed, he purportedly attempted to use a crowd of supporters that he had gathered in Washington, D.C. to pressure the vice president to fraudulently alter the election results. Speaking to that crowd on January 6th, Trump falsely claimed, based on fraud, the vice president could alter the outcome of the election results. When this crowd then violently attacked the Capitol and halted the proceeding, Trump allegedly delayed in taking any step to rein in the chaos he had unleashed. Instead, in a last desperate ploy to hold on to power, he allegedly attempted to exploit the violence and chaos at the Capitol by pressuring lawmakers to delay the certification of the election and ultimately declare him the winner. That is the backdrop against which this case comes to court. Up to this point, by the way, basically, so when people say, oh, well, how do we know that we're right and the conservatives aren't right? Like maybe we're the crazy ones, right? Aren't we both saying the other side is crazy? So the difference is conservatives don't deny any of this happening. All of this happened and they won't deny any of it. They'll just say that like, oh, well, it's not a big deal and he should have been allowed to do it. That's the difference, okay? If conservatives were the same conservatives they were 10 or 15 years ago, they would have the shame and they would have the wherewithal to at least deny the behavior, right? Like when a rapist gets caught raping somebody, right? That well, she consented. Well, she wanted me to fuck her. I didn't know that she didn't blah, blah, blah. But like when a conservative gets caught, it's like, so I should have the right to rape her. I don't give a fuck. That's the difference between today's like MAGA conservatives versus like the neocons in the past is the lack of shame, I would say. The court now confronts a question it has never had to answer in the nation's history. Wait, hold on, we need music. What am I looking for? Wasn't your argument that Biden shouldn't be able to be impeached for a quid pro with the Ukraine thing because it was an official policy? What official conduct can be prosecuted or impeached for? Do we need to do like a... You know what? Actually, I will write this. I'll do a note on this officially because I've dug into this a bit because conservatives just never seem to understand this. When Biden was saying that the United States wasn't going to provide aid unless Shokin was fired, the loan guarantees that the United States were providing were conditioned on Ukraine fixing up their prosecution system and the corruptness in that office. That's what that aid was conditioned on. That wasn't a quid pro quo. That wasn't him getting something for doing something. That's why he said it publicly and nobody thought anything about it at the time because everybody in the world understood that that's what the European Union, that's what the European nations, that's what the United States was pressuring Ukraine to do because Ukraine was one of the most corrupt, no offense, one of the most corrupt fucking countries in the world at the time, or at least in Europe. Current current conversation. Oh. How naive. What did I just say that was incorrect? And one could not just brush it off. Even if no foul play at all, it's a talking point, and people chase quick dopamine releases nowadays. Okay, fine. If you want a quick dopamine release, then here we go. Under your quid pro quo idea, you're asserting that Joe Biden, the vice president of the United States, has convinced Obama and the entire U.S. to fire one judge in Ukraine to save his son, okay? The level of expansive corruption there is massive. If he's willing to do all of that, why would Joe Biden allow his DOJ, his FBI to investigate his son, to charge his son, and then to convict him in a novel manner for a crime? I already know your answer, because you always have an answer. And the answer is, well, because it was so public this time, there's no way that they would have gotten away with it. There's no way they would have gotten away with it this time. That's your only answer. That's the only answer that you have. Like, I don't even, can you even bend your fingers anymore from how thick the calluses have to be on your knuckles from dragging them across the floor for the entirety of your existence to say something that fucking stupid? There would be flash flood warnings if people related to you were allowed to exist in a city because of how much fucking drool would come out of your mouth all fucking day long. How stupid you would have to be to answer that way. And it's the only answer you can give, okay? Extra strength, Drano. Okay, I'm never going to finish reading this. Start, the majorities brought official acts immunities inconsistent with text history and established understandings of the president's role. Moreover, it is deeply wrong, even on its own functional terms. Next, the majority's core immunity is both unnecessary and misguided. Furthermore, the majority's illogical evidentiary holding is unprecedented. Finally, this majority's project will have disastrous consequences for the presidency and for our democracy. Infra means that it's like referenced within this document, right? That's essentially what it means, I think? Yeah, okay. So we've got Sotomayor argues in 5 parts. Is legally and historically inconsistent. It is deeply wrong, even in its own functionalist terms, that it is deeply wrong that the core immunity is misguided and not needed. The evidentiary holding is unprecedented. Doesn't necessarily make it bad, but that the ruling will have disastrous consequences. Hello?
Just real quick, just wanted to let you know, the judge in the New York hush money case, he has postponed sentencing until September because of the Supreme Court's decision. So yeah, it may affect it.
Why? They shouldn't affect him because these were actions taken before being president, right?
Well, I think the hush money payments occurred after, like the actual transactions themselves, if I remember correctly, they took place after he was elected.
So in the case where Donald Trump is so fucking late in paying any of his fucking bills, might have actually paid off for him.
Right. So I sent you the link, the official ruling from Judge Merchan, and you can check it out when you've got time.
Have you watched Ben Shapiro's video on this yet? I feel like I'm going to watch it. I'm going to lose my fucking mind. It's an hour long. Somebody linked it to me. I might, if I have time before then I showed it, I don't watch it, but oh boy.
No, I've not. And I just want to remind you, keep this in mind when you do watch his reaction, and you can check this out. I'll send you the link too. In 2014, he literally wrote a book calling for the prosecution of President Obama. So just keep all of that in mind, that 10 years ago.
Keep in mind that you know what Obama did that would be unreviewable?
Mm-hmm.
If Obama ordered the IRS to just tax conservatives, they shouldn't be able to review that action. In fact, they should fully say, well, hold on, we don't want to, infringe on the president's ability.
It's an executive branch agency,
yeah,
right?
exactly. Why the fuck would you have any review over that, right? Yeah, it's unbelievable, dude.
Yeah, so brace yourselves when you watch that.
Okay.
All right, buddy. I'll talk to you later.
Okay. Hold on, I gotta do something real quick. Actually, wait. Fuck it. I'm grabbing something real quick. Or ordering something.
So yesterday, pretty much...
I'll watch like the first few minutes of this while I order. What if Trump goes to jail but wins the election? What happens if New York refuses to release him? We have no clue. That's all uncharted territory.